Good morning, Ms. Mulligan.
Good morning. May it please the Court. Diane Mulligan for the plaintiff appellant Leanne Mason. The question before the Court today is whether or not the probate court can make an initial order of child support against an estate.
After somebody's dead.
After somebody's death, yes. Against an estate after somebody's death, yes. And the facts in this case are that Leanne Mason is the mother and appointed guardian of Jessica L. Manning. Jessica is the non-marital daughter of a long-term relationship between Leanne Mason and Mr. James Manning. Mr. Manning died in a motor vehicle accident in April of 2006. Following the breakup of the relationship between Ms. Mason and Mr. Manning, the breakup of the relationship was amicable. And there was an agreement between the parties as to how Mr. Manning was going to support the non-marital child, Jessica. Jessica was 6 years old when the parties' relationship ended.
Can I ask you, does any of this make any difference at all as to whether the court can do this? Do any of these facts make any difference at all?
The facts I think that do make a difference are that Mr. Manning voluntarily and willingly and generously supported every aspect of this child's life. And the
critical fact is he's the father, and that's admitted.
And was she acknowledged?
He acknowledged over and over again. That's correct.
I have a question for you. Assuming your argument is correct, what about, does it mean that the father in a two-parent marriage, where there's a mother and father who are married to each other and they have a child, is that father obligated to support his children until they reach 18 after he dies?
Under Massachusetts, yes. I'm sorry.
So
in a
the
divorce,
father dies.
so
the father dies, and his estate has to pay for the child?
If they're divorced?
No, they're still married.
They're still married. Well, the estate would, under normal circumstances, pass to the wife. And in fact, that's what we have going on.
That's right. And suppose the wife says, I'm not, well, the wife has to pay for the child.
That's right.
But
The wife has to, the mother has to pay for
the
the
mother
the
would have to,
child, so
right.
that would
So the
answer that
support of the
question.
children would come out of that parent's
May
estate.
I ask you this? In this particular case, the father acknowledged he was the father. He made arrangements. He was paying support. But what if we agree with you, that might also apply to situations where the father does not acknowledge paternity, where there's an argument that he's the father, he's dead now. What happens then? Would they be able to get his DNA? Would they ask for a court order to get to his body so they could take DNA?
I understand the implication of that, but I think that there is no condition precedent in the statute that even paternity has to be established. But 209C is a paternity statute. So
You can bring, I mean, I take it under Chapter 197, Section something or another, within 6 months or whatever that period of time is, 6 months, 9 months, you can bring a paternity action. So I think Justice Ireland's question, the mother of this child could, as long as it was timely, bring an action at least to establish paternity.
which is what we did, Your Honor.
Right. No, I understand that, but
okay.
I mean, and
Yes.
then you get to 209C, but you could do that.
1 year. The
Yeah,
time
it's 1
period's
year.
1
Yeah,
year.
but
Yeah.
here we have a child who's 6 years old, and so,
No, 1 year of death.
yes.
Yes.
Excuse me?
1
It's
year
1 year
death.
of death. You
From
bring-
1 year
time
of
of
death.
death.
Yeah, exactly.
You
6
establish
years old when they
paternity.
split. She's now 15. She was 13 when he died. And so there was a long period of time in which the support was taking place. So if I'm understanding the question, I understand the difficulty if somebody is dead and buried and getting DNA and proving paternity. But I think those are evidentiary issues that, certainly would be brought before the probate court.
2 years, in the 2 years since he died.
Yes.
And this has been going on. Have payments been made, or is everything just in suspension?
There have been no payments made from his estate. She is receiving his Social Security benefits. There was...
She the child is.
Excuse me?
She the child, not
She the child yes, she the child, and there were 2 marital children, because he did. Mr. Manning was married did have 2 marital children, and those
And how
marital
much-
children are being taken care
In
of.
general
out of-
terms, what are the assets of the estate?
It's quite a lucrative estate, Your Honor. Very financially able. He owned, and it is still operational, a very lucrative business on Nantucket Island, installing home theaters. He owns substantial real estate. He owns a home, all on Cape Cod, one on Nantucket. One home that has no mortgage whatsoever, another home that was purchased for $1.5 million,
Okay.
and another business
Now, you
for
said he
$2.5
died in a
million.
car crash. Was there any lawsuit over that?
It was not. It was a single car
Car
crash, Your
accident.
Honor, and the understanding is that he lost control of the vehicle.
Fine.
Ms. Mulligan, assuming that the court says, yes, this child has the right to have payments until she's 18, practically, how does that work with this estate? I mean, does the estate need to stay open for all that period of time? How do you do that?
Well,
Well, you have a fixed amount and you net present value it, don't you?
yes,
I mean,
yes.
there's no, I mean, wasn't he paying a certain amount?
$50 a week,
He was paying $50 a week, but
plus
he
some expenses.
Private school.
exactly. He paid about $19,750. He paid for private school and so forth. But the interesting thing is, case law also in Massachusetts says that she is a preferred creditor of that estate as well. So I don't know that the estate would stay open for a long time, and the logistics of the actual
Well,
payment.
It must have been dealt with in the cases where, I mean, it's clear if the order's made before the guy dies.
That's right.
It survives, so that could conceivably could be for 18 years too, right? As long as the order, that's clear, it can be done before he dies.
The only issue in this case is that there was no order in
Correct.
place.
But
That's
the
exact-
problem of the order extending out a long period of time has
Just
been true for a long time
Yes, yes, it has.
in orders that are made before they die.
That's right, that's right. It's by statute, exactly. The payments would continue on
Maybe
until
as
18.
was suggested, there's, kind of a lump sum payment and close the estate, and maybe not.
Well-
Maybe a reserve is kept and the rest of the assets are distributed,
Yeah.
there are various ways to do it.
There are ways to do it.
Investments,
There are
annuity
ways to do it,
contracts,
yes.
all kinds of stuff.
None of that discussion has taken place yet, no.
So if we go your way, then there's 2 years of payments that gotta be made up, right?
Yes, but there will be offsets because of the Social Security benefits that she's been
Well,
receiving.
the probate court will deal with that.
Exactly, those would be evidentiary issues for the probate court. There was a life insurance policy that did go to her, so
She was the beneficiary?
she was the beneficiary, yes.
Is there an
But
issue,
again,
is there an issue, assuming that we were to agree with you, just assuming, is there an issue as to whether it goes to age 18 or 21?
no, in terms of the payments coming out of the estate?
Yes?
Well, I would think it would be statutory again. The statute reads that it's until 18. If the child is, is still dependent on the parent and in college, it would be until age 23. But again, there are other elements here,
It's who is domiciled in the home of the parent and is principally
dependent on that parent.
Okay, you say you assume it's statutory, so that it would go only till 18. Where in the statute is there anything about an order entering after someone's death, making him responsible for paying the support of the child?
That occurs in 119A, which this court has construed 209C is the paternity statute, 119A being the child enforcement statute. And the evolution of the jurisprudence of this court has been always to construe those statutes together. 119A, the Child Support Enforcement Act, has the definition of obligor as, among other things, an estate which may owe a duty of child support.
Who owes or may owe
Owes or may owe, that's right,
duty of support.
a duty of support.
It
And
seems
so-
to me that if you get the order beforehand, you owe.
Exactly, but if you don't, you may owe, yes, which is our position.
There's a duty of support. It is not taking under the will, because did he leave money to this child?
He did not. She was named in the will, along with the other 2 marital children, as a beneficiary. But the way the will was drafted, the assets went to the wife,
Okay.
went to his wife.
She was a residuary legatee, right?
I think in the event
I
of
mean,
a
if
co-disaster.
if the wife had predeceased
Exactly,
him, then
yes.
she would have gotten a third of the estate.
Yes, she would have gotten a third of the estate, but as, as typically the estate went to the wife. And the wife is still running the business. The business is still operational. The tragedy really is not only has she lost her father, but she's also lost some of the relationship with her stepmother and her stepsisters because they've now relocated over onto Nantucket. And they had a very close relationship. And
This is
fully
irrelevant. This
Excuse
is
me?
irrelevant to the issue.
It is irrelevant to the issue, but there's been a lot of damage that has flowed from this awful tragedy, and the fact that she has lost her financial security has been devastating. Mother works, mother takes care of her as well. She does get the Social Security benefits, but father really went out of his way to make sure that every need, every necessity, and every luxury that she may want, she got. I mean, she certainly understands that the luxuries are gone at this point in time. He was a very generous father, but it has been said over and over again in the case law that that legislative action and the evolution of the jurisprudence of this court has been to protect children, especially those who may be stigmatized by the issue of being illegitimate. And that is the hallmark of the jurisprudence of this court. And I think that this is one of those cases that certainly continues that evolution of taking care of supporting non-marital children.
I mean, in part, why wouldn't, for example, the father making the daughter the beneficiary of a life insurance policy on his life be part of that obligation? I mean, his view of how one fulfills that obligation. I mean, so how do the life insurance proceeds mix into this?
Well, I would
They would be a credit,
Suggest-
wouldn't they?
excuse me.
Wouldn't they be a credit?
Yes, I would suggest that
are
only
credit.
in determining how much, if anything,
Okay.
this estate may have to pay, which again would be an
So
evidentiary.
like
question.
like the Social Security offsets.
Exactly.
life
It would be an
insurance.
offset.
Right, I understand that.
Absolutely, would be taken into
Out
consideration.
of
And now
curiosity, how big was the insurance policy?
it's $200,000.
Okay.
So that, which for the matter of what we're here today, I feel is not relevant to this particular issue, but certainly will be relevant. And of course, all of this took place after, the life insurance policy took place after this case was reported up by the probate judge. But I still think the issue of whether or not an initial order can be made against the estate of a parent is what needs to be determined. And again, it's looking at the legislative intent of the statutes. Chapter 119A read together, construed together with 209C. And this court has already determined in LWK versus ERC that the obligation to support a child survives the death of a parent. So that leg of the decision has already been made. It survives the death of a parent. The obligation does. And ironically, if there was an order in place, or if they were married, she would be receiving child support out of the estate. And the only difference is that there was no order in place, yet we have a father who voluntarily supported his daughter. And I also provided a case from New Mexico, just as instructive, because there is no case in Massachusetts directly on point of this issue. It has an analogous statute. It's an analogous case. And in that situation, the court did determine that an order was of support against an estate. Given that the court has broad latitude in interpreting statutes having to do with child support.
The defendant argues that actually the New Mexico statute isn't the same, that it has a specific authorization for what the court did there, and in fact the difference, he would say, speaks volumes.
Yeah, well, they're actually, the UPA statute in New Mexico is the paternity statute. Our paternity statute is 209C. However, 209C is construed with 119A. So the same 119A, which is the enforcement statute. So the exact language that appears in the UPA, in the New Mexico statute, almost exact, appears in 119A. And that is the entire Massachusetts statutory scheme. And I would go on to say that the equity statute would also give this court the power to determine that the probate court can make this order, because the equity statute is also construed with 119A.
Thank you, Ms. Mulligan. Mr. Spillane?
May it please the Court, Attorney John J. Spillane of Worcester, representing the appellee, my brother Matthew T. Spillane of my law firm. In order for the appellant to prevail, it's necessary for her to show that the probate court has the power to bind an estate with an initial award of child support after the death of a decedent. And it's well settled that the concept of alimony and child support is statutorily based. And this court in Getterman versus Cameron stated that there's no non-statutory right to sue for alimony or support.
Is that the case that the Judge Drebin said needs to be looked at again? In the
Clark,
Clark decision is?
I'm unaware of that,
Okay.
Justice.
well, she did say that it's in the judge's order. Clark versus Barba, that Getterman ought to be looked at again. And I guess that's what we were here to do today.
Certainly. And, Your Honor, at the time that the appellant brought her action in the probate court, she sought to avail herself of the rights and liabilities which are in Chapter 209C.
Well, she was doing 209C plus 119A plus the paternity statute.
I think the record shows
190 Section 7.
The record shows that the protections that she applied for in the probate court were under Chapter 209C. The complaint to establish paternity was brought, and subsequent to that, there was a motion for temporary orders that
Why should, putting Getterman aside for a minute, but why should the unfortunate circumstance of an accidental death remove somebody's right to pay child support?
Well,
I mean, does that make any sense, particularly if they have, as the case is here, otherwise they couldn't sue for it practically, substantial assets in the estate?
well, I'd like to correct what my sister said. The assets there are assets, but they're not as my sister had
Well,
represented
if
to
the
the court.
assets are finite, then the obligation would end and so forth, but why should there be a difference?
Well, in this particular circumstance, the parties did not avail themselves of the protections of 209C. There was a de facto circumstance where
And we would say that that was helpful rather than hurtful, namely if there's an acknowledgement of paternity.
and there was, Your Honor.
There's clearly an acknowledgement. Let me follow up on Justice Glaney's question. What you have here is that the mother of the marital children receives from the estate, and she plainly has an obligation to support her minor children, correct?
Yes.
She attempted to say, I didn't have this obligation before his death. He made all the payments, and now I've inherited the estate, and I don't choose to support my children. She wouldn't have a leg to stand on, correct?
Well, I think there are other protections that those children would have.
Correct. And it is the strong policy of this Commonwealth that marital and non-marital children be treated alike, correct?
And Chapter 209C did establish that.
And his
Correct.
wife was fully aware of this other child, right?
Oh, yes. There was a very harmonious
Does the
relationship.
ALI restatement on the law of family dissolution have anything to say about this circumstance?
I'm sorry,
The
Justice.
ALI restatement of family dissolution, I think that's what it's called, have anything to say about this?
Principles of family dissolution.
Have you looked at that?
I have not.
And have you
Justice,
looked
I'm
at
not
what the
familiar.
ALI revisions say about what in their restatement on trusts?
I'm not sure I understand the question.
Well,
Justice.
there are two ALI sources. One is the principles of family dissolution. The other is the restatement on trusts and estates.
Yes. Again, I'm not familiar with those, so we'll
Mr.
look at them.
Spillane, I can see a strong public policy argument to be made for saying that there ought to be some authority for imposing a child support order even after someone passes away. But I can't think of a public policy argument to support your position. Is there one?
Well, I think certainly parties need to avail themselves of the protections under Chapter 209C. In this case, Mr. Manning went to his grave as a stranger to the court, and now this action was contemplated after the source of his generosity had dried up. I certainly think from a public
I
policy
don't think it was
point of view-
generosity. I think if there'd been any suggestion that he didn't have support obligations for this biological child, the mother would have gone to court, obtained a determination of paternity, and he would have been obligated. I mean, it's turning the statute on its head that says when somebody it's like saying, I voluntarily agree that I owe you some obligation, and then when I'm deceased, somebody saying, well, you didn't go in and have the court order you to pay that. Why would you do that? Why would you want to clog up the probate and family court with, biological parents, mothers and fathers, who voluntarily support their children, not only because they love them, but because they know they have an obligation to support them?
Well, many times the Commonwealth has promulgated child support guidelines, and certainly I would represent to this court that it's important for parties to avail themselves of court intervention so that support orders can be fair and
If somebody's
enforced.
not paying, if somebody wants to pay more,
Or
I have no
somebody-
idea whether these are consistent with whether his payments to her were consistent with the guidelines or more.
Or conversely, if somebody pays less,
Well, then
the court-
no doubt she might have
There-
gone in.
there's-
the court has a way of
Well, he
ensuring
was paying
fairness.
$20,000 a year, wasn't he?
He was paying a tuition to Sacred Heart Academy in Duxbury, approximately $9,000, and with all the extracurricular activities and the weekly support, which he voluntarily paid, it was approximately $19,000.
He didn't voluntarily pay it. He had an obligation as her biological father. The fact that it didn't have a court order, that's like saying if I walk into a store and I get something, I voluntarily pay. I don't voluntarily pay. I have an obligation to pay. He had an obligation to support her.
But with all due respect, Your Honor, that obligation was never adjudicated.
Of
in-
course
in
it
the
wasn't
forum
adjudicated,
within
but
which-
an obligation doesn't cease to be an obligation because there isn't a court order.
Well, the courts have been very clear in some of the language in the decisions in the LWK case that there is a public policy argument in the Commonwealth that parents support children.
And
Well, the
he
statute, the Children Out of Wedlock statute says explicitly every person is responsible for the support of his child born out of wedlock from its birth to age 18.
And
At a minimum.
Justice Cordy, I believe the statute goes on to say that that they need to avail themselves of the protections of the chapter, and I believe that's Chapter 209C. So my position
They need
is
to
that-
avail themselves in order to,
Yes.
in other words, the right isn't, the obligation isn't an obligation
I think
unless
the-
the court orders it?
I think the obligation is a statutory obligation. It's derived in the language of the statute, and it's not something which exists out there in the air, so to speak.
It cannot be, can it, that we have as a policy that you have to go to court because otherwise you're going to be out of luck if people are voluntarily complying with what the court would otherwise order?
Well, I think a lot of times people don't understand what a support is and what it entails. The fact that there are guidelines which and a lot of great thinking and rationalization went into the promulgation of the child support guidelines in Massachusetts. Many people don't understand the concept of health insurance and who pays health insurance when even both mother and father have health insurance. The appellee believes that court intervention is needed so as to make sure that there is a fair and equal result in support orders. And my position is that in this case, the parties did not avail themselves. And to argue from on behalf of the estate, Mr. Manning certainly had no understanding of what his visitation would be, or his custody, or whether he could take the child and see and take visitation with the child for a period of time. The estate believes that the parties needed to have that order of support originate in through Chapter 209.
Why
Mr.
can't it-
Mr.
why-
Spillane, I think that we understand your position that in the absence of a court order, you don't have an obligation to support. Can I just turn your attention, though, to the definition of obligor in 119A? What do we make of the language, is an individual, the estate of a decedent, who owes or may owe a duty of support? What support are we talking about other than child support?
Well, that language, again, Chapter 119A is the enforcement arm. The 209C and Chapter 119A are two mutually exclusive statutes. They are not to be read together. One statute does not usurp the power given to another statute.
No,
Wouldn't you
you
think they
read them.
should be read together? I mean, one establishes various court procedures for confirming obligations, for getting various court orders that are then enforced in 119, and they're certainly, the whole term obligor, appears in 209C and 119.
With all due respect, Justice, I don't believe it appears in 209C. It does appear in 119A, but I don't have the language right in front of me. The 209C deals with an origination of a support order. 119A deals strictly with enforcement. And to answer the Chief Justice's question, the legislature did use that language to anticipate the nebulous period between when a complaint for paternity is filed pursuant to Chapter 209C and the time frame that occurs when that complaint is adjudicated. We all know that certainly not everybody
And what is your
stipulates
what is your
paternity.
Mr. Spillane, forgive me, what is your basis for saying that it's that specific time period that the legislature had in mind, particularly in light of the fact, if you could answer the question, of Section 190, Chapter 190, Section 7, which provides for the establishment of paternity after?
Yes, Your Honor. It's common practice in the probate courts of the Commonwealth that when a complaint for paternity is filed, a complainant can request interim support from a probate court judge. And my understanding in my practice is that probate judges routinely will grant orders of temporary support while there is an adjudication pending on paternity.
Presumably, if the court determines on a preliminary showing that there's a likelihood that the man is in fact the father.
I would
correct?
submit to Your Honor that that is not necessarily the standard. Judges will, if there's an affidavit that's completed by the mother, the courts will order support, and then later, if it's adjudicated that father is not in fact the father of the child, there is no right of reimbursement back for the monies that are paid pursuant to a temporary order of support. Hopefully I've answered your question, but that language which defines obligor being somebody who owes or may owe a duty of support certainly contemplates, I think the legislature contemplated death occurring during that nebulous period before a formal adjudication of paternity had entered. And however, that statute, 119A, does state that that the enforcement mechanisms in the statute will be liberally construed.
But again, the establishment of paternity must be commenced, I'm now looking at 197, Section 9, within 1 year of the date of the decedent's death. And you seem to be suggesting that if the determination of paternity was commenced before the decedent's death and there were temporary orders, then the may owe a duty of support would continue because the decedent...
Post-mortem, yes.
But where you have a statute that says that you can in fact establish paternity after the decedent's death, why are you eliminating that as a basis?
I believe that is the formal adjudication of paternity. It can exist under the enforcement piece of the statute post-mortem. But the complaint has to be filed prior to somebody's death.
But the statute says that you can-
predate 209C? This paternity part? Or?
197, I believe, is founded in estate law, and that means that a creditor of an estate must bring a claim against that estate within 1 year of the date of death in order to prevail as a secured creditor. Justice, I do not know the answer to that question. I wouldn't even hazard a guess. My sense is it probably did predate the Chapter 209C and Chapter 119A, which was codified by the legislature in 1986.
Mr. Spillane, the term obligor does appear in 209AC, 209.
Thank you. I don't have the text in front of me.
Sorry.
Thank you, Justice.
Thank you, Mr. Spillane.
Thank you,